Hey guys, just doing a couple of cards on contracts, and this contract card has a thing about prospective buyers, and the question is, a seller thought that the prospective buyer might be at default on a sales contract, so he tendered the deed and demanded payment. What does tender mean? If you know, that's great. Okay, tender has several meanings in real estate, and in this case it means to pay or deliver. It can also mean to perform under contract. For example, offering money or rent under a lease. An offer to perform an obligation together with actual performance or evidence to present ability to perform. For example, offering to pay a debt that has been demanded. Okay. Tender. Not something I usually hear out there. All right, here's one we've heard of, forfeiture. What is it meant by forfeiture? This is under contract. To forfeit is to give up or abandon. Forfeiture is loss of money or anything else of value because of failure to perform under contract. An example is Baker, a prospective purchaser, fails to keep up payments under the land contract and thus forfeits his right to the property. What is rescission? A good one. To rescind. Rescission is an act of rescinding. Rescission is an act of rescinding. That is, withdrawal, canceling, or terminating a contract. Rescission is allowed when the contract was induced by fraud, duress, misrepresentation, or mistake. Additionally, Regulation Z allows one to rescind certain credit transactions within 3 business days, and purchases of certain land that must be registered by the Department of Housing and Urban Development, or HUD, may rescind within 3 business days. Another under contract here. What is default? We've heard that before. Not a great thing. Default is failure to fulfill an obligation or promise or to perform specific acts. To default. For example, a contract may require a buyer to close within 3 business days. If a buyer fails to appear at the closing, this constitutes a default under contract. The buyer is in default. Similarly, if a borrower fails to make payments on a loan for 3 months, he has defaulted on the loan, and the lender can foreclose the property. A delinquency on the loan is failing behind on a payment and is often cured easily. Default on a loan occurs after continued delinquency. What is specific performance? All right, we know what performance means. This is specific to that performance. This is all under contract. Specific performance is a legal action in which the court requires a party to a contract to meet the terms of the contract when they have refused to fulfill their obligations. Okay, so we have specific performance is a legal action in which the court requires a party to a contract to meet the terms of the contract when they have refused to fulfill their obligations. So they're going into a court setting that's being forced. When you sue for specific performance, you are suing to force the other party to do what they said they would do. Specific performance is often permitted by courts in real estate matters because each parcel of real estate is unique or non-homogeneous. For example, Baker agreed in writing to sell his house to Abel. Baker changed his mind when his adult daughter decided to buy the house. Baker offers to refund Abel's earnest money deposit and pay living expenses for 1 month. But Abel insists on buying the house as agreed and will sue for specific performance if Baker refuses to sell. That's a sad thing, huh? Well, the daughter should have come earlier, I guess. But you never know with kids. What is a breach of contract? We've heard this. This is familiar. Breaking of a contract. Under contract. So breach means breaking. Breach of contract is a violation of all or part of a legal agreement within a legal excuse. Without a legal excuse. Breach of contract allows the non-breaching party, the one who didn't break the terms, to rescind the contract, sue for damages, or sue for specific performance of the contract. Okay? Go over that again. Breach means breaking. Breach of contract is a violation of all or part of a legal agreement without a legal excuse. Breach of contract. Breach of contract allows for non-breaching party, the one who didn't break the terms, to rescind the contract, sue for damages, or sue for specific performance of the contract. An example is Baker contracts with owner Brown to purchase the property. When the closing date arrives, Brown refuses to convey title to the property. Brown's action is not supported by any special condition in the sales contract and therefore constitutes breach of contract. Baker may rescind the contract and recover his deposit, sue Brown for any expenses and damages incurred, or sue to force Brown to sell under specific performance. Liquidated damages is an amount determined by the parties, agreed to be paid to the party injured by the other party's breach. That's a good one. And that happens frequently out there. We've got a couple of more, and then we're going to put this in a little chunk. What are some things that may prevent a real estate sale contract from closing? What are some of the things that may prevent a real estate sales contract from closing? Real estate contract may fail to proceed to closing as a result of breach of contract, default, and rescission. All the things that we just discussed. Okay, we have the next card. This again is contracts. What is meant by performance of the contract? Which is opposite of non-performance. But let's see here. Performance is the completion of duties and obligations specified in a contract. An example is Patty, the tenant, and Bruce, the landlord, agree on the terms of a 5-year lease. Both parties abide by the lease for the entire 5 years. The lease expires upon performance of the parties upon the end of the full term, 5-year term. Okay? And that's what we have for contracts for today. And we'll do another set and publish that. And thanks a lot, guys. Hope you had fun learning a few keywords.